Within the solemn and august setting of the Supreme Court's chamber, adorned with cool marble, Denzel Washington stood poised at the rostrum. His suit, a deep charcoal hue, was impeccably tailored, providing a striking contrast to the gleaming mahogany. His gaze remained unwavering, fixed on Justice Amy Coney Barrett. A profound quiet, charged with expectation, filled the air as Barrett leaned into her microphone, her voice cutting through the silence. "Mr. Washington, you are an actor without formal legal training, yet you presume to enlighten this court on matters of constitutional law." Her tone was sharp, imbued with a clear sneer. "Perhaps your talents are better suited to interpreting scripts, not scrutinizing legal briefs." A collective gasp rippled through the crowded courtroom. Barrett's unexpected, pointed jab at the celebrated actor caught everyone off guard. Yet Washington remained utterly composed. A faint, knowing smile touched his lips as he subtly adjusted his notes. "Your Honor," he began, his voice calm, yet resonating with quiet authority, "what I am about to present before this court may indeed astonish not only you, but every individual present." The other justices exchanged brief, inquisitive glances. Barrett had just made a public attempt to discredit Denzel Washington before the nation's highest judicial body, seemingly unaware of the true intellectual depth of the individual standing before her. This was no mere performer, and the subsequent 5 minutes were destined to redefine the entire narrative. If you're just joining us, be sure to click that subscribe button and inform us of your viewing location. You absolutely will not want to miss the dramatic climax of this extraordinary legal confrontation. The Supreme Court chambers hummed with hushed conversations as Justice Amy Coney Barrett settled back into her imposing chair, her demeanor radiating a cool, self-assured calm. At 52, Barrett held the distinction of being the youngest justice on the bench, her appointment having been accompanied by significant public discussion. She was widely recognized for her incisive questioning and her steadfast adherence to an originalist interpretation of the Constitution. Today's proceedings, focusing on a highly publicized civil rights case, had already garnered national attention, but no one had anticipated a Hollywood icon assuming the role of legal advocate. Denzel Washington, now age 70, maintained his composed posture at the podium, globally celebrated for his compelling performances in films such as Philadelphia, Training Day, and The Equalizer. What remained largely unknown to the public was his private, decades-long immersion in constitutional law. Beyond his well-known acting career lay a man who had, for over 2 decades, quietly audited law courses at esteemed institutions, including Harvard, Yale, and Georgetown. His invitation to participate in this pivotal case was not as a celebrity endorser, but rather in recognition of his extensive, privately undertaken scholarly work on civil rights law, a depth of knowledge he had meticulously kept from public view. "Justice Barrett," Washington commenced, his voice carrying the same resonant authority that had captivated cinema audiences for decades. "I stand before this court not as an actor, but as a citizen who has dedicated thousands of private hours to the rigorous study of the very foundation of our legal framework." Barrett's dismissive smile lingered. "Mr. Washington, this court has heard from countless advocates possessing legitimate law degrees and decades of professional experience. What singular contribution could you possibly offer that they have not already provided?" The stakes could not have been more critical. This case was poised to determine whether local governmental bodies possess the authority to restrict peaceful protests in certain residential areas, a ruling that could potentially curtail the fundamental free speech rights for millions of Americans. Civil rights organizations had tirelessly campaigned for years to bring this landmark case before the Supreme Court. Washington had been brought into the legal team only after 3 previous attorneys had failed to make substantial headway against the government's arguments. "Your Honor," Washington calmly continued, "I fully grasp your skepticism, but occasionally the most incisive perspective emerges from outside the conventionally established system. The question before us today transcends mere legal precedent. It directly concerns the practical application of constitutional rights for the ordinary American citizen." Barrett absently shuffled her papers, her disinterest plainly evident. We have no need for philosophical musings, Mr. Washington. Our requirement is for legal arguments firmly rooted in established precedent and the precise text of the Constitution. The rapid clatter of the court reporter's fingers on the keyboard underscored the escalating tension. The other 8 justices observed intently, some displaying genuine curiosity, others maintaining a clear air of skepticism. Chief Justice Roberts appeared particularly captivated by the unique unfolding of this unprecedented confrontation. In the gallery, civil rights attorneys from the ACLU exchanged uneasy glances. Had their decision to invite Washington been a profound miscalculation? Barrett was clearly intent on making an example of him, to emphatically demonstrate that celebrity status held no influence within the nation's highest court. Washington squared his shoulders, entirely unfazed. With the utmost respect, Justice Barrett, I believe I can offer both. And if you would extend me the courtesy to proceed, I am confident you will find me more prepared than you might anticipate. Barrett gestured dismissively. Very well, Mr. Washington. You have precisely 20 minutes. Endeavor to impress us with your purported expertise. Little did she comprehend that she had just issued a profound challenge to an individual who had been meticulously preparing for this precise moment for a period longer than her entire tenure on the bench. Justice Barrett, I wish to commence with Hague v. CIO, 1939, Washington stated, citing the case without even a glance at his notes. The court in that instance unequivocally ruled that public spaces have been historically utilized for collective assembly and the unfettered communication of ideas among citizens since the very inception of our country. This enduring tradition, it held, should not be curtailed without truly extraordinary justification. Barrett's eyebrows arched imperceptibly. She had clearly not expected him to begin with such directly relevant case law. That particular case is now over 80 years old, Mr. Washington. Surely you recognize that jurisprudence has evolved considerably since then? Washington nodded respectfully. Indeed, Your Honor. That is precisely why I would like to meticulously trace the subsequent evolution of public forum doctrine through Edwards versus South Carolina, Cox versus Louisiana, and leading up to McCullen v. Coakley in 2014, where this court unanimously invalidated buffer zones around abortion clinics as clear violations of the First Amendment. Justice Samuel Alito leaned forward, his demeanor suddenly engaged. And how, then, would you differentiate the neighborhood restrictions currently at issue from the buffer zones addressed in McCullen? Washington turned his attention directly to Alito. I would not distinguish them, Justice Alito. That is precisely my central argument. In both instances, the government asserts a compelling interest in the maintenance of public safety and order. However, in both instances, the imposed restrictions unduly burden substantially more speech than is demonstrably necessary to achieve those stated interests. Barrett interjected, her voice now acquiring a sharper edge. Mr. Washington, merely reciting case names is one thing. Comprehending the nuanced subtleties of First Amendment jurisprudence is an entirely different matter. The neighborhoods in question possess thoroughly documented histories of violent incidents following prior protests. With due respect, Justice Barrett, Washington calmly countered, the record before this court indicates that violence occurred in only 0.3% of protests in these specific areas. Yet, the ordinance restricts all demonstrations, irrespective of their demonstrably peaceful nature. A ripple of murmurs spread through the spectators. That, Your Honor, is precisely the type of over-inclusiveness that this court decisively rejected in McCullen. Washington was not merely holding his own. He was directly challenging and refuting Barrett's characterization of the factual record. Justice Sonia Sotomayor swiftly interjected. Mr. Washington, the government contends that these neighborhood restrictions constitute content-neutral time, place, and manner regulations. How do you respond to that assertion? That demonstrably fail under intermediate scrutiny, Justice Sotomayor. Washington replied without the slightest hesitation. The regulations do not leave open ample alternative channels for communication. The affected neighborhoods encompass crucial government offices and significant historical landmarks that hold specific symbolic value for protesters. As this court explicitly noted in City of Ladue versus Gilio, alternative locations may prove fundamentally insufficient when the precise place itself is an integral part of the message being conveyed. Barrett's expression visibly hardened. This was clearly not proceeding as she had anticipated. She had fully expected to effortlessly expose Washington's supposed lack of legal acumen. Instead, he was demonstrating an astonishing command of First Amendment case law that would be the envy of many highly experienced attorneys. "Let us move beyond mere case citations, Mr. Washington," Barrett stated, her voice tinged with impatience. The original understanding of the First Amendment surely did not envision modern protests involving amplified sound equipment and massive gatherings that possessed the capacity to paralyze entire neighborhoods. It was a direct challenge, a deliberate attempt to draw Washington into deeper, more complex constitutional waters where she fully expected him to falter. The courtroom became palpably tense. "I have meticulously studied originalism, Justice Barrett," Washington responded calmly. "In fact, I have read every one of your academic articles on the subject." Barrett blinked, visibly taken aback. The historical record clearly shows that the founders were intimately familiar with disruptive protests. The Boston Tea Party was hardly a quiet affair. Neither were the widespread demonstrations against the Alien and Sedition Acts. If we closely examine how the founding generation actually behaved, rather than simply their written words, we plainly observe that disruptive public protest was unequivocally considered a core component of American political expression. Washington then reached into his briefcase and produced a well-worn, leather-bound book. This is a first edition of St. George Tucker's 1803 View of the Constitution, one of the earliest and most significant commentaries on the American Constitution. Tucker explicitly notes that the right to assemble and petition was understood to be protective of public demonstrations, even when they proved inconvenient to authorities. Chief Justice Roberts leaned forward, his interest visibly piqued. "You have read Tucker's commentaries, Mr. Washington?" "I have, Chief Justice, along with William Rawls' 1825A View of the Constitution, Joseph Story's commentaries, and the complete Madison Papers regarding the drafting of the First Amendment. The historical record is abundantly clear that the founders valued protest as an essential check on governmental power, even when, and perhaps especially when, it caused disruption." Barrett's face flushed ever so slightly. She was a renowned originalist, celebrated for her exhaustive historical research. Yet Washington was now displaying a depth of knowledge regarding founding-era sources that few lawyers, even those specializing in constitutional law, ever bothered to consult. "And how would you respond to Justice Scalia's opinion in Ward versus Rock against racism, where he emphasized the government's compelling interest in protecting residents from unwelcome noise and disruption?" Barrett countered, citing her late judicial mentor. "With respect, Justice Barrett, that was Justice Kennedy's majority opinion, not Justice Scalia's." Justice Scalia joined it in full without writing separately. Washington corrected gently. A profound, tense silence descended upon the courtroom. Washington had just, with utmost politeness, corrected Barrett on a factual point of Supreme Court history. Several justices shifted uncomfortably in their seats. Barrett's face visibly tightened, a fleeting flash of embarrassment quickly superseded by resolute determination. "My mistake," she stated coolly. "Let us now turn to the application of Ward to the present case." "Certainly," Washington nodded. "Ward does indeed establish the government's legitimate interest in limiting excessive noise. However, it also unequivocally requires that any such restrictions be narrowly tailored. The ordinance here bans all demonstrations in these neighborhoods, irrespective of noise level or time of day. That is substantially broader than necessary under Ward's precise standard." Justice Elena Kagan nodded slightly, appearing subtly impressed by Washington's precise legal analysis. Barrett was not yet finished. "Mr. Washington, you articulate these legal principles as if they are purely academic concepts. But as a justice, I must consider the practical realities. Residents in these neighborhoods possess rights too. Rights to peace, to security, and to the unobstructed use of their streets. Washington paused, then responded with quiet, yet palpable, intensity. Justice Barrett, before I pursued a career as an actor, I grew up in precisely those types of neighborhoods. I have personally experienced the reality of being told where I could and could not gather, where my voice was and was not welcome. The practical reality is not merely inconvenienced homeowners. It is citizens being told they cannot exercise fundamental constitutional rights in significant public spaces simply because their presence might be deemed inconvenient. The personal note in his voice visibly shifted the energy in the room. Washington was no longer merely reciting legal principles. He was connecting them to a lived experience in a manner that clearly resonated with several justices. Barrett pressed on, her voice acquiring a sharper edge. Emotional appeals aside, Mr. Washington, the Constitution does not guarantee the right to protest wherever one pleases. Surely even you must acknowledge that some reasonable restrictions are permissible. Of course, Your Honor, the question is not whether any restrictions are permissible. It is whether these particular restrictions are consistent with established precedent and fundamental constitutional principles. And on that critical question, I firmly believe that the historical record, this court's established jurisprudence, and the specific facts of this case all point to the same inescapable conclusion. They are not. The tension in the courtroom had reached its absolute zenith. What had commenced as Barrett's deliberate attempt to humiliate a prominent Hollywood actor had been utterly transformed into a substantive, rigorous constitutional debate with a surprisingly erudite advocate, and Washington showed no signs of retreating. Justice Barrett leaned forward, her patience visibly wearing thin. Mr. Washington, let us cut directly to the core of the matter. You have, I will concede, memorized some cases and historical references. But the complex, delicate balancing of rights that we are charged with performing demands genuine legal training and extensive practical experience. Do you not perceive a certain presumption in your standing before this court? The pointed challenge hung heavily in the air. This was Barrett's final, direct attempt to reassert her authority, to remind everyone that he was, at bottom, merely an actor presuming to be a lawyer. The courtroom fell into complete silence, all eyes fixed upon Washington. He took a deliberate breath before formulating his response. Justice Barrett, with sincere respect, I would like to clarify something that may have been overlooked. Washington then reached into his briefcase and calmly retrieved a document. This is a certificate from Yale Law School, where I audited constitutional law in 1998. Since that time, I have audited 17 more constitutional law courses at Georgetown, Harvard, and Columbia. Murmurs, audible whispers, spread throughout the courtroom. Barrett's expression froze in place. I have also actively participated in moot court competitions as a volunteer advocate and have dedicated thousands of hours to the specific study of First Amendment jurisprudence. Washington then pulled out another document. And this is a letter from Professor Lawrence Tribe acknowledging my contributions to his research for American constitutional law. The gallery erupted in quiet whispers. Justice Thomas raised his eyebrows in subtle surprise, while Justice Kagan offered a slight nod of acknowledgement. My intention is not to boast, but rather to suggest that we should exercise caution about making assumptions. The law, Your Honor, belongs to all Americans, not exclusively to those possessing formal degrees. Barrett remained utterly still, her earlier confidence visibly shattered. She had publicly sought to diminish Washington based on preconceived notions about his legal knowledge. And now those very assumptions were being systematically dismantled before the entire court. Chief Justice Roberts cleared his throat. Mr. Washington, that is quite impressive, but let us now return to the specific merits of the case at hand. How would you propose we craft a ruling that respectfully balances both the right to protest and the legitimate concerns regarding residential peace and public safety? Washington nodded, clearly grateful for the return to substantive legal argument. Chief Justice, I firmly believe the optimal solution lies within this court's well-established time, place, and manner jurisprudence. The current blanket neighborhood bans extend far beyond what is demonstrably necessary. A properly tailored ordinance would regulate excessive noise, particularly during night hours, prevent the blocking of residential driveways and entrances, and perhaps reasonably limit the duration of protests in purely residential areas. But, he continued, gaining discernible momentum, such regulations must never prevent all meaningful protest in areas of genuine public significance. Government buildings, historic sites, and public parks located within these neighborhoods must remain accessible for First Amendment activity with reasonable restrictions, rather than outright bans. Washington then produced a document that dramatically altered the dynamic of the proceedings. If I may, I have prepared a concise analysis of 70 similar ordinances from across the country that have been consistently upheld by various circuit courts. He handed copies to the clerk to distribute to the justices. These comprehensive examples clearly demonstrate how cities have successfully balanced these competing interests without resorting to overly broad neighborhood-wide bans. Justice Neil Gorsuch studied the document with evident interest. "This is quite thorough, Mr. Washington. Did you compile this information yourself?" "Yes, Justice Gorsuch. Over the past 6 months, I personally reviewed every circuit court decision on this specific issue from the past decade. The patterns are unequivocally clear. Narrowly tailored restrictions have been consistently upheld, while broad geographical bans like the one before us today have been struck down in 87% of such cases." Barrett finally spoke again, her tone now distinctly different, devoid of its earlier disdain. "Mr. Washington, your research is, I must admit, impressive, but I am genuinely curious about your perspective on a related question. How would you address concerns that allowing protests in these areas might regrettably lead to violence? Even if past instances have been rare?" It was a genuine inquiry. The confrontational edge had completely vanished from her voice. Washington had undeniably earned her professional respect. "That is an important and valid concern, Justice Barrett," Washington readily acknowledged. "I believe the fundamental solution lies in behavior-based restrictions, rather than preemptive bans. Law enforcement agencies already possess the authority to effectively address actual violence or imminent threats. What they should not possess is the power to prevent constitutionally protected activity based on mere speculation about what might occur." Washington paused, then added, "As this court wisely noted in DeYonga versus Oregon back in 1937, the right to peaceful assembly is a right cognate to those of free speech and free press and is equally fundamental. We do not ban books because some books might contain harmful ideas, and we should not ban peaceful assemblies because some assemblies might, hypothetically, lead to harm." Justice Sotomayor nodded approvingly. "Well articulated, Mr. Washington." Barrett, now fully engaged with the substantive legal arguments rather than focusing on Washington's credentials, followed up with another question. "But does not the government possess a special, compelling interest in protecting residential privacy? This court has clearly recognized this in cases such as Frisbee versus Schultz." "Absolutely, Justice Barrett," Washington replied, clearly appreciating her shift to a substantive legal debate. "Frisbee is indeed directly relevant here. But crucially, Frisbee upheld a ban on targeted protests focused on a single residence, not sweeping neighborhood-wide bans on all demonstrations. The ordinance at issue here extends far beyond Frisbee's specific holding. Washington was no longer being treated as an interloper or a mere celebrity. He had entirely transformed the dynamic of the courtroom, earning the court's respect through his evident mastery of the subject matter. Barrett, who had begun by attempting to humiliate him, was now engaging with him with the same intellectual rigor she would apply to any accomplished advocate. Justice Brett Kavanaugh, who had remained silent until this point, now joined the conversation. "Mr. Washington, how would you address the argument that these particular neighborhoods have unique security concerns due to the presence of several government officials' homes?" "That is a fair and important question, Justice Kavanaugh," Washington responded. "The government certainly possesses greater latitude regarding security measures for public officials. However, the current ordinance does not limit itself to security concerns immediately surrounding officials' residences. It broadly bans demonstrations throughout entire neighborhoods, including areas with no discernible security significance. Washington continued, a properly tailored ordinance could effectively create security buffers around specific residences while leaving other public spaces readily available for First Amendment activity. The current approach is akin to using a sledgehammer when a precise scalpel is required. Several justices nodded in agreement at the apt analogy. As Washington's allocated time drew to a close, Barrett posed one final question. Her tone was now undeniably respectful, even collegial, a complete and striking reversal from her initial condescension. Mr. Washington, given your unique perspective, both as someone who has meticulously studied the law extensively and as a public figure who profoundly understands the power of public demonstration, how would you articulate the core value we, as a court, should be diligently protecting here? It was precisely the kind of thoughtful, open-ended question justices often reserve for advocates they held in high regard. The courtroom held its breath as Washington carefully considered his response. Justice Barrett, I profoundly believe that the core value at stake is democratic participation itself. When we restrict where citizens can assemble based on mere geography rather than their actual conduct, we are, in effect, telling some Americans that their voices are less welcome in the public square. That, Your Honor, fundamentally cuts against the foundational principle that all citizens possess an equal right to participate actively in our democracy, a principle that transcends partisan divides and varying constitutional methodologies. Washington concluded, whether viewed through an originalist lens or a living constitutionalist perspective, the First Amendment's robust protection of assembly and petition powerfully reflects our shared understanding that a healthy democracy inherently requires public spaces where all voices, regardless of their origin, can be heard. I respectfully urge this court to affirm that vital principle today. As Washington returned to his seat, the entire courtroom seemed to collectively exhale. What had begun as a calculated attempt to humiliate a celebrity had been utterly transformed into one of the most compelling and intellectually substantive oral arguments the court had heard in years. Barrett's expression was now thoughtful, perhaps even tinged with a subtle hint of contrition. She had discovered, very publicly, that Denzel Washington was indeed a legal mind to be reckoned with. As Denzel Washington descended the Grand Supreme Court steps, a blinding cascade of camera flashes erupted around him. Reporters shouted questions, but Washington offered only a dignified nod before stepping into his waiting car. Inside, the justices had already retreated to their private chambers. The story exploded across every major news network. CNN's prominent headline blared, "Denzel Washington stunned Supreme Court with legal brilliance." Fox News ran with "Hollywood star schools Barrett in surprising showdown." MSNBC's banner declared, "Washington versus Barrett. Actor reveals secret legal expertise." Video clips of the exchange spread with viral speed across all social media platforms. Barrett's initial dismissive comment, swiftly followed by Washington's revelation, had already garnered over 5 million views on TikTok within mere hours. He didn't just hold his own. He completely owned the courtroom, explained a CNN legal commentator, visibly awestruck. "I've observed Supreme Court arguments for 30 years, and I've never witnessed anything remotely like this." On Fox News, a former Justice Department attorney noted, Washington approached this using Barrett's own originalist methods and was undeniably more thorough in his historical research than the government's own attorneys. The ACLU legal team that had brought Washington into the case celebrated cautiously. "We knew Denzel had been diligently studying constitutional law for years, but even we were astonished by the sheer depth of his preparation." Sources close to the court privately revealed that Barrett reportedly told her colleagues, "I made assumptions about his capabilities that proved entirely unfounded." It was a valuable and humbling reminder that genuine legal expertise can emerge from the most unexpected sources. By evening, The phrase legal genius was trending nationwide. A particularly compelling clip where Washington gently corrected Barrett about Justice Scalia's opinion had been viewed over 12 million times. A former Supreme Court correspondent succinctly tweeted, "In 25 years covering SCOTUS, I've never seen a justice as utterly caught off guard as Barrett was today." Washington knew the law better than she would have expected from even a seasoned advocate. The story quickly expanded far beyond traditional legal circles. A Harvard law professor commented, "What's truly impressive isn't just that Washington knew the cases, but that he possessed a sophisticated understanding of how they seamlessly fit together within the broader framework of constitutional law." On Capitol Hill, Representative Jim Jordan remarked, "It was truly refreshing to see someone outside the entrenched legal elite demonstrate such profound command of our Constitution. The founders clearly intended the law to be accessible to all citizens." Senator Elizabeth Warren added, "This incident powerfully highlights the persistent gap between our judicial system and ordinary Americans. It absolutely should not require being Denzel Washington to be heard respectfully in our nation's courts." Later, Yale Law School announced the establishment of the Denzel Washington Public Advocacy Fellowship for Non-Traditional Legal Advocates, a groundbreaking initiative. Washington himself released a concise statement. "The Constitution belongs to all Americans. I sincerely hope my appearance encourages others to actively engage with our legal system, regardless of their formal background." For Justice Barrett, the powerful exchange became a defining moment early in her Supreme Court tenure. Initially portrayed in some media as an embarrassing public misstep, many discerning legal observers eventually came to view her remarkable willingness to engage substantively with Washington after her initial dismissal as a profound sign of genuine judicial humility and intellectual openness. Supreme Court historian James Simon noted, "What's truly remarkable is how swiftly Barrett pivoted from outright dismissiveness to genuine, thoughtful engagement. That admirable ability to set aside preconceived assumptions and focus intently on the intrinsic strength of the arguments presented is, in fact, an admirable and crucial judicial quality." Across the nation, law schools reported a significant surge of interest in their auditing programs and public lecture series. Georgetown Law Center's public constitutional law lectures, in particular, witnessed attendance triple in the weeks immediately following the Washington argument. There's something incredibly powerful about witnessing someone pursue knowledge purely for its own sake, not solely for professional advancement, explained Georgetown Law Dean William Traynor. Washington diligently studied law for 20 years with absolutely no intention of practicing. That specific kind of intellectual curiosity deeply resonates with people. As for the specific case itself, sources close to the court strongly suggested that Washington's compelling argument had significantly influenced the justices' collective thinking. Astute court watchers widely predicted a 7-2 or possibly even an 8-1 decision striking down the neighborhood protest bans, while simultaneously providing clear guidelines for more narrowly tailored, constitutionally permissible restrictions. 6 weeks later, when the court formally issued its landmark ruling in Martinez v. City of Phoenix, those widespread predictions proved strikingly accurate. In a commanding 7-2 decision, authored by Chief Justice Roberts himself, the court definitively struck down the broad neighborhood-wide protest bans while, at the same time, acknowledging that more limited restrictions could indeed be constitutional if they were meticulously and properly tailored. Most surprisingly to experienced court observers, Justice Barrett wrote a concurring opinion that cited Washington's argument directly. As Mr. Washington eloquently submitted during oral arguments, genuine legal expertise is not solely confined to those with traditional credentials, and the robust protection of First Amendment rights often requires an examination of historical context and practical implications that transcend narrow interpretations. The Supreme Court's decision, heavily influenced by Washington's nuanced presentation, sent a clear message nationwide. Blanket bans on peaceful assembly, even in residential areas, were constitutionally suspect. Cities across America began re-evaluating their protest ordinances, leaning towards more narrowly tailored regulations, focusing on behavior rather than location. For Justice Barrett, the experience became a pivotal moment in her judicial philosophy. While her commitment to originalism remained, many observed a subtle yet significant shift in her approach to oral arguments. She was reportedly more inclined to ask open-ended questions, probing for deeper understanding, and less likely to dismiss arguments based on the advocate's background. Her concurring opinion in Martinez versus City of Phoenix, directly referencing Washington's argument, was seen by many as a powerful testament to intellectual honesty and judicial humility. The Denzel Washington effect resonated far beyond the legal community. Enrollment in public constitutional law courses and civic engagement initiatives saw a noticeable rise. People inspired by Washington's example began to realize that the Constitution truly was accessible to everyone, not just legal scholars. His appearance became a celebrated example of how passion, dedication, and meticulous study could challenge entrenched assumptions and influence even the highest echelons of power. Washington himself continued his quiet scholarly pursuits, occasionally giving guest lectures at law schools, always emphasizing the importance of civic literacy and engagement. He never sought to formally practice law, preferring to use his unique platform to encourage others to understand and defend their constitutional rights. The day Denzel Washington argued before the Supreme Court would forever be etched in legal history as a moment when celebrity met scholarship, and the public square expanded just a little bit more.